Good morning, everyone. I hereby call this meeting of the House Judiciary to order. This is our sixth meeting of the regular session. Mr. Clerk, please call the roll.
Representative Banta.
Present.
Representative Bauman.
Present.
Representative Blanton.
Present.
Representative Burke. Representative Dietz.
Here.
Representative Flannery.
Here.
Representative Griffey. Representative Kulkarni. Representative Lewis.
Here.
Representative Maddox. Representative Marzian. Representative Moser. Representative Nemus.
Here.
Representative Petrie.
Here.
Representative Roberts.
Here.
Representative Stevenson. Representative Whitaker. Representative Williams.
Here.
Representative Wilson.
Here.
Vice Chair Decker.
Present.
Chair Elliott.
I'm here.
And so we do have a quorum, and we're duly constituted to conduct business this morning. We have two bills for consideration, and we're going to limit discussion on each bill to 30 minutes. And the first bill is House Bill 5, which is sponsored by Vice Chair Jennifer Decker. And if you want to proceed to the table, and your guests can come up and everyone can introduce themselves, and then you can proceed.
Mr. Chairman, I'd like to make a motion on the committee sub.
I second the motion.
There's a motion and a second to adopt the committee sub. All those in favor, please say aye. Aye. Those opposed, no. And the sub is adopted. And you may proceed after introducing yourselves.
My name is Jennifer Henson Decker. I am from District 58. I will ask my guests to introduce themselves.
Ryan Quarles, President of KCTCS.
I'm Kerry Harvey. I work in the governor's office.
Chris Crumrine, Director of Government Affairs with KCTCS.
Good morning. Thank you, Chair and committee members. Thank you for the opportunity to present House Bill 5 today, an act relating to prison education programs. This legislation authorizes KCTCS to partner with the Kentucky Department of Corrections to build and operate a model vocational training campus at North Point Training Center, which is an existing medium security prison for men in Bergen, Kentucky. As my guests will explain, this bill delivers a common sense, evidence-based strategy to advance each of Kentucky's core public safety objectives. HB 5 is not a soft on crime initiative. It does not shorten sentences or reduce accountability. Through my guest testimony, you will learn that our state faces a dual challenge: public safety and workforce demands. The bill's framework is straightforward in addressing both of these challenges head-on. Michigan implemented and then expanded a similar prison educational program that it calls vocational villages. And after doing so, recidivism for program graduates dropped to less than half of the 30% of the general population, prison population in Michigan. For a number of years, the recidivism rate of Michigan's vocational villages has been 12%. Our team has studied Michigan's model intensively. We visited there firsthand, saw their facilities, observed their operations, and met with leaders who designed and scaled their program. In those conversations, Michigan told us they wished they had built a stronger partnership with their state's technical colleges from the outset, which House Bill 5 does. Michigan's results are not theoretical. They are proof that HB 5 is grounded in real-world evidence and delivers a proven, data-supported return on investment. Safer communities, dramatically lower reincarceration rates, and a stronger workforce that helps create more productive, tax-paying citizens. Under House Bill 5, qualifying inmates will complete training in high-demand fields, earn KCTC credentials, and be held accountable every step of the way. This initiative will lower recidivism, accelerate workforce development, help address Kentucky's labor needs, and deliver long-term security savings to society through reduced reincarceration rates. Specifically, House Bill 5 does the following things. It provides for the creation of a memorandum of agreement between KCTCS and the Kentucky Department of Corrections, outlining the partners' respective responsibilities. It provides for facility construction and operations managed by the respective agencies. It requires strict eligibility criteria and security safeguards. It requires data collection and annual reporting on program outcomes. And it amends current law to support reentry documentation, including certificates of employability and employment protections. That's what the bill does. And if there are no questions, I will defer now to my witnesses, the experts, for more detailed testimony about the bill.
Thank you, Representative. Thank you, Chairman. Also want to say thank you, Representative Decker, for being a champion on this. We started this concept almost a year ago in her office, and look at where we're at today. Also want to say thank you to Senator Storm over in the Senate, and also Secretary Harvey, Jackson, Commissioner Cruz, and of course our case TCS team and our friends at BCTC, which this facility will be attached to. Case TCS is rolling off some great numbers. Our enrollment's up, 110,000 enrollees. 74% of our students walk across stage with no student loan debt. And as you all know, we have a commitment to every Kentuckian, whether they're in our recovery community, whether they're behind bars, whether they're going back to college for the first time as an adult learner. And today's bill, House Bill 5, does three things. It saves Kentucky money, it prevents crime, and it fills jobs and workforce needs. And at this time, I'd like to introduce Secretary Harvey to discuss the recidivism issues in Kentucky and how House Bill 5, we hope, will cut those in half.
Good morning. I appreciate the opportunity to return to this committee and appreciate all of you for being willing to hear this very important bill. First, I want to say how appreciative I am of the partnership that the Department of Corrections has formed with Representative Decker, with President Quarles and his team. I think over the last year we've developed a very close working relationship built on shared goals and mutual trust and respect, and I think we have a good bill before this body today. I've been a prosecutor in the state courts of our Commonwealth as well as the federal courts, and I've had a hand in putting thousands of people behind the walls, and I thought all of them needed to go. But I've observed that almost all of them return to our communities. And so it is very important that we return better people to our communities than what we took into our facilities. House Bill 5 will do just that. House Bill 5 builds on existing reentry efforts. Over the last few years, the Department of Corrections have been able to implement very important evolutionary advances in our recidivism reduction efforts. We've instituted more than a dozen new vocational programs in our facilities across the Commonwealth, including now an operating licensed cosmetology school in our women's prison, which we're very proud of. And as important as these evolutionary steps have been, House Bill 5 represents a revolutionary advance in our reentry and recidivism reduction efforts. House Bill 5 will represent a quantum leap forward for the Commonwealth of Kentucky. The House Bill 5 program will have many beneficial aspects, but it rests principally on two bedrock public policy imperatives. First, it will reduce crime. The House Bill 5 program does not replace prosecution or punishment for criminal conduct. It is not a get-out-of-jail-free card. It will, however, turn out inmates who are substantially less likely to commit new crimes upon release from prison. The House Bill 5 program is a law and order program. Every police officer and every prosecutor knows that the best law and order program is the one that prevents crimes from occurring in the first place. House Bill 5 will reduce recidivism, which is a fancy way to say that we will have less crime and safer Kentucky communities. Second, House Bill 5 preserves the public fisc. As House Bill 5 reaches full implementation, the Commonwealth saves money. For every successful reentry attributable to this program, we will gain a tremendous amount of direct savings and the indirect cost of crime prevention. We will enhance Kentucky's workforce, and we will create taxpayers instead of prisoners. There are many benefits to House Bill 5, but the headline reads that it reduces crime and it saves taxpayer dollars. This body, in KRS 196.032, mandates that the Department of Corrections will hold offenders accountable and will institute programming to reduce recidivism. House Bill 5 more perfectly fulfills these policy goals established by the General Assembly long ago. President Quarles.
Thank you. So what's the need in Kentucky? This slide, as you can read, shows we have currently about 12,000 state prisoners across 14 facilities, 13 men's prisons, one female prison in Pewee Valley. And so for us, we currently have a presence in these prisons. We're teaching, as you'll see in the next slide, we're actually teaching in all these prisons, plus one federal prison, and as many jails as we are welcomed across Kentucky as well. But what makes this work in Michigan is that it's not only an availability of premier educational programming, but it's a connection with known employers that want to hire from the second chance population. We've worked with many organizations, and we've identified well over 300 employers willing to hire somebody that has a felony conviction. And when you look at these 12,000 state inmates, 7,000 which are housed in our county jails, 95% of them will be released. They'll go back to sometimes to the county that they're from, and they're going to be our neighbors. So you got to ask a question: who do you want to be your neighbor? Do you want someone who's had opportunity to benefit from our programming and get a job? And I think this is something that House Bill 5 specializes in. Next slide. And as you can see, we're already currently facilitating GEDs across Kentucky. We just celebrated over 3,000 GEDs among our incarcerated population in 2024. But also, House Bill 5 will help supplant but not replace the programming we have at our jails, our prisons, and our federal prison as well. The genesis around House Bill 5 is creating one centrally located, state-of-the-art facility that offers programming that, quite frankly, cannot be offered at our current prisons, whether it's a lack of jail, lack of enrollment, or lack of faculty available in that part of the state. And so what we plan to do is build upon what we're already doing. Right now we have about 550 incarcerated state prisoners that are enrolled with KCTCS, and they're getting A's and B's. And this helps us provide a more narrowly tailored programming that aligns more perfectly with second chance employers across Kentucky. And so we're proud of the work we're doing, and House Bill 5 helps us take it to the next level.
Reentry programming works. We know this. Upon release, inmates return to Kentucky communities, and they do so in the thousands every year. As has been discussed, we had a chance to visit the vocational villages programs in Michigan, and they have the data that shows that their programming works. We believe that the House Bill 5 program will actually be qualitatively superior to the program in Michigan for a couple of reasons. One is that we'll be located at one facility, and the inmates in the program will be totally immersed in reentry and learning how to reenter society. They'll be separated from the rest of the population that has a longer way to go. What they will do in this program will mimic the workday once they are released. The second primary reason why this will be a superior program is that unlike Michigan, our community college system, which is the gold standard for vocational education, will be the turnkey provider of this important job training. And that's something that the return on that will be incredible. And I just would like to draw your attention to a couple of the hypothetical outcomes, but something that plays out in the real world in Kentucky every day, every week, every month, every year. First, let's consider an inmate who has done his time. He's ready for release. He's going home, but he's not well equipped to return to a society that is probably far different from the one he left a few years ago. An inmate who has not acquired the life skills necessary to cope with the challenges of day-to-day living, and an inmate who does not have the job skills necessary to land a decent job. That's an inmate that is far more likely to fail. What's the look of a failed reentry? What are the consequences to our communities? A failed reentry quite likely means new crimes are committed and innocent Kentuckians are victimized. Law enforcement agencies, local jails, local prosecutors, and the judiciary are burdened with yet another case. Eventually, the failed inmate is again sentenced to a Kentucky prison, and taxpayers bear the substantial cost of his incarceration. But the costs don't end there, they only begin. The inmate leaves his family behind. Instead of supporting his children, that burden often falls to taxpayers through necessary but expensive public benefit programs. And those children, as we know, the children of people who are incarcerated are themselves far more likely to live in poverty and turn to crime themselves. The cycle of crime, poverty, and hopelessness continues. The chains seem to be unbreakable. But there's another happier outcome that House Bill 5 will promote. Let's consider an inmate that receives the kind of preparation for a return to society that House Bill 5 will provide. He knows how to cope with the problems we all encounter in daily life. He has the job skills necessary to land a decent job that will allow him to support his family on his own without help from the taxpayers. He experiences the dignity of honest work, and he has hope for a better future. In my experience, hopeful people are far less likely to commit crimes. His children have a role model. These little ones, who themselves are victims, have a better shot at a fulfilling life. Our community gains a hardworking, productive, law-abiding citizen. He's a taxpayer, not an expense. These two remarkably different outcomes play out every day in our Commonwealth. House Bill 5 will not eliminate recidivism. Some will fail, but House Bill 5 will undoubtedly produce more successes than we see today. And with each additional success, the gains are real and important for Kentucky communities. These gains are cumulative. They mount over time, and House Bill 5 will sunder generational chains of crime and poverty for many Kentucky families. So House Bill 5, I believe, embodies our shared values of accountability, responsibility, and redemption. House Bill 5 is good for the Commonwealth of Kentucky. It will make us a safer, more prosperous state. And I appreciate your thoughtful consideration of this proposal.
Chair, I heard a question on Bill's former legislator. That means maybe time to vote.
That's what it sounds like, Dr. Quarles, and you remember that from your time here, so. But you may have some concluding remarks.
Let me just wrap this up in 30 seconds here. What you're seeing on the screen is North Point potential sites here, 51,000 square foot facility, state of the art. And next slide, if you don't mind, here are the programs that we are proposing. The cool thing about this is that we can add to or subtract depending on the success of these programs. There's no appropriation requests in this bill. We have filed through the normal process. But these programs are ones that we have listened to the employers of Kentucky first to see whether or not there would be a high successful rate with second chance employment. Just want to say thank you to our partners, Goodwill Industries, Tucky Chamber, United Way, and others as we build a coalition with that reentry process. With that, thank you, Representative. Thank you, Mr. Chair.
Thank you, Vice Chair Decker, for sponsoring this legislation. I just wanted to highlight the programs that are going to be available. Advanced manufacturing technology, welding, carpentry, HVAC, diesel mechanic technology, electric lineman technician, computerized machining, additive manufacturing, heavy equipment operations, computer engineering technology. So these are all very marketable professions that these folks will be able to go into. And this is going to be in Boyle County. So I can't let that go by without noting that this morning. Representative Moser.
Thank you, Mr. Chairman. And I don't really have a question. I just have some comments. I love this bill. This is a great initiative. It's something that is near and dear to my heart. When I served as drug policy director up in Northern Kentucky over 8 counties, we talked about this a lot. We talked about reentry and and how to reach folks who are living in this cycle and how to reduce relapse and recidivism. So I see this as a very natural extension of any second chance programs. I see this a natural extension of actually a bill that I passed, I don't even know, 2019, 2020, the certification of employability to ensure that inmates were being trained during their incarceration period and that they left with some skills. And so I see this as a very positive extension of that. And that, by the way, was also a Michigan initiative. So I totally stole that idea. It was a great one. So I just want to encourage everyone to support this initiative. I think it's a great project. Thanks for bringing it.
Thank you.
Mr. Chairman, if I could comment
Yes.
just briefly.
Yes, please.
Uh,
We
as
have 6 minutes.
Okay,
under
as
my-
it so
under my
happens, the Secretary
time rule.
Harvey and I graduated in the same law school class. And one of the things we were taught there is that one of the goals of good public policy in this area is to rehabilitate and reduce recidivism. So that's what this bill does. It's not a new idea, as you mentioned, but it is a revolutionary way to carry that out. Thank you.
Right, I would agree. I'm sorry for interrupting or speaking out of turn. I've just always said that corrections should be a correction. So, thank you.
Representative Kulkarni.
Thank you, Mr. Chair. Thank you all for bringing this very, very important, necessary, and good bill. I had a quick question about the data collection piece, which I'm very thankful for. I think it's really important for us to be able to track the success of these programs. I just had a very simple question on page 3, number 2. So it's, there's different data collection in terms of receiving an offer of employment prior to release, and I was wondering if we could track the successful employment of folks that have gone through the program after they've been released, and that would be in number 2 of that same section.
Yes, we would encourage that. That way we can show the ROI on this project, and I know that's what Michigan does as well, because the employment trends change, or there might be an employment opportunity that wasn't there in the first wave when we get started, hopefully fall of next year.
And I think the Department of Corrections through the Reentry Services Division will be able to do that, also in cooperation with probation and parole, which will, not all, but for most people involved in this will be still under supervision if they're released through parole as opposed to serve out. So we'll have a couple of ways to track that and keep up with those folks. And of course, that's very important because we want to make sure that what we're doing is working as intended.
And I just wonder if the sponsor would be open to a friendly amendment, just specifying that additional line.
I would certainly like to talk about that, and it sounds like a great idea.
Okay.
Thank you.
Thank you. Thank you, Mr. Chair.
Thank you. So we have a motion and a second. Mr. Clerk, please call the roll.
Representative Banta,
No.
Representative Bauman,
Yes.
Representative Blanton,
Aye.
Representative Burke, Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Flannery. Representative Griffey. Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Marzian.
Yes.
Representative Moser.
Yes.
Representative Nemus. Representative Petrie.
Yes.
Representative Roberts.
Briefly explain my vote.
Please.
Mr. Chairman, if an ex-con is going to come to my house, I hope it's with my permission and it's to fix my HVAC or build a cabinet. So I love this bill. I love this idea. Definitely prefer that to the alternative, so I'm a yes.
Representative Stevenson. Representative Whitaker.
Yes.
Representative Williams.
Yes.
Representative Wilson. Chair Elliott.
Aye. So with 19 yes votes, 1 no vote, no pass votes, House Bill 5 is amended by the committee substitute is passed. So congratulations and thank you for
Thank
being
you,
here this
committee.
morning.
Thank you.
And the next item on the agenda is House Bill 468, which is
Thank you.
my bill, so I will turn the meeting over to Vice Chair Decker and proceed to the table. Good morning. Nice to see you.
Chair Elliott, will you please introduce yourself and your guest?
Thank you, Madam Chairman. Good morning. And I'm Daniel Elliott. I'm the state representative for the 54th Legislative District, and I'll allow my guest to introduce himself.
Good morning, ma'am. Joe Bilby. I'm the Deputy General Counsel for the House of Representatives.
Your phone.
Again,
Microphone.
my name is Joe Bilby. I'm the Deputy General Counsel for the Speaker of the House.
Thank you. Thank you. You may proceed.
Thank you, Madam Chairman and members of the committee. House Bill 468 is a bill that makes updates to the Kentucky Civil Rights Act, which was amended in 1992 by the General Assembly to prohibit discrimination on the basis of disability in a manner similar to the Americans with Disabilities Act of 1990. Congress updated the ADA's definition of disability in 2008, and this bill would conform state law to its federal counterpart. The Kentucky Supreme Court in Turner versus Norton Healthcare called upon the General Assembly to bring clarity to the issue of whether the federal amendments should be incorporated into the Kentucky Civil Rights Act. And this bill amends the Kentucky Civil Rights Act to provide that the phrase qualified individual with a disability is to be interpreted consistently with the Americans with Disabilities Act amendments of 2008.
Motion on the bill, Madam Chair. Second.
Are there any questions, comments?
Representative Stevenson.
Thank you, Madam Chair. The question I have is, does this bill strip the commissions of their authority to hear cases and cause people to have to go into the court system?
Well, thank you for the question. It does remove the adjudicative power of the Kentucky Human Rights Commission in matters related to employment and public accommodations. Now, it does not remove their investigative powers and their other non-adjudicative functions, and it leaves the complaints related to housing discrimination, it leaves those powers unchanged with respect to the adjudicatory authority. But it does remove it. And the reason that I am proposing this is I believe that the right to a jury trial, which is enshrined in the Kentucky Constitution and enshrined in our Seventh Amendment to the U.S. Constitution, is the appropriate forum for these complaints. And the Kentucky Human Rights Commission would still be able to initiate litigation on behalf of a complainant if they thought that was necessary. So I just think the appropriate forum is the courts and not an administrative agency.
Thank you.
We do have people signed up to speak. Oh. Representative Kalkani.
I apologize. Thank you, Madam Chair. Based on that last answer, I was just wondering what the impact would be on the courts, or anticipated impact or fiscal impact, anything like that.
There was a local mandate, and I thought I had printed that off. I don't know if that's in the sheets or not, and I'll yield to.
There was a local mandate document generated that concluded that. Thank you. There was a local mandate analysis that concluded that the impact would be minimal to moderate. We were able over the summer months, ma'am, to reach out to the staff of the Kentucky Commission on Human Rights, and they were very responsive and professional to work with. We asked for data about the number of charges that have been filed each year, going back to 2019 and beyond. The Commission has 3 silos of cases that they adjudicate. Claims of discrimination of employment, which is the most numerous, claims of discrimination in public accommodations, and claims of discrimination in housing. And what we asked for information on each of the cases that have been filed so we could see if 100 are filed, how many make it to a hearing, how many are settled, how many are dismissed with a finding of no probable cause. And just taking the year 2019 as an example, in that year, in the employment silo only, they had 211 charges received. 145 of those were dismissed for no probable cause. 35 were withdrawn pursuant to some sort of settlement. There was 1 confidential settlement, but none of those 211 actually resulted in a hearing. And so if we've done our math correctly in examining the data that the Commission gave to us, there are only 1 or 2 hearings a year that are held by the Commission. So we look at that and say that if those hearings were instead to occur in a circuit court setting, it's hard to see that it would be in any way, burdensome on the courts or create an opening of floodgates that the courts would be unable to handle. Because, of course, courts handle these cases all the time. Most plaintiffs pursue them in a civil action at the outset without even going to the Commission. And so this is an effort to move cases that have in the past been adjudicated before an administrative law judge without a jury, and instead say they need to be adjudicated before a jury.
Thank you. Thank you for that explanation.
Yes, ma'am.
Now we will go to the people who have signed up to speak. Colt Sells and perhaps Cedric Irvin Jr. with her. Okay, thank you. We need to limit the comments to 5 minutes, please. You may introduce yourselves and then proceed. Thank you.
Thank you, Madam Chair, and thank you to members of the committee. My name is Colt Sells, and I'm staff counsel for the Human Rights Commission.
Good morning, everybody. My name is Cedric Irvin Jr., and I'm the enforcement supervisor with the Kentucky Commission on Human Rights.
Thank you. You may proceed.
Thank you. And thanks again for the opportunity to be here before you today, and thank you to the sponsor of the bill, Chairman Elliott, and this committee for their interest in the commission and its work. This is my first appearance before this body, and I would expect it's the first in a long time for the commission. So before I begin, I'd like to just make clear that the commission and its staff is here to answer every call of the members of this committee as well as members of the General Assembly to work together to figure out what's best for the people of Kentucky. we're here to work together to ensure that all Kentuckians are safeguarded against unlawful discrimination in their pursuit of housing, in employment, and in places of public accommodation. House Bill 468 seeks to make several sweeping changes to the state civil rights law. Some of the changes are overwhelmingly positive. As Chairman Elliott stated, resolving the question of whether or not the KCRA incorporates 2008 amendments to the ADA. Of course, the Commission thinks that those amendments are incorporated in the state law. House Bill 468 would answer that question for us. And it would answer that question for a lot of Kentuckians, a large portion of which are individuals with one or more disabilities. Roughly 1/3 of the Commission's complaints are filed on the basis of disability. That change is obviously a positive one. I've also long been a critic of the structure of the KCRA, and this bill seeks to take steps in the direction to update, to modernize, and to make clear the rights and obligations of folks under the Kentucky Civil Rights Act. And some of those changes are long overdue. However, the Commission's concerned that House Bill 468 will have the practical effect of creating more problems than it solves. The largest change made by this legislation is the replacement of the ability to hold administrative hearings with the requirement to file civil actions instead. The bill would also remove almost all the powers of the local human rights commissions created under the statute. While I'm less clear at this time the impact of the proposed amendments on the State Commission, I do worry that this legislation, if passed as written, would render ineffective the ability of local governments to enforce local ordinances. I think there are some folks in here from those local governments. If they choose, I'll let them speak for themselves on the impact on local commissions. Also, the bill would allow for folks to opt for both the administrative remedy as well as a judicial one. And I question what impact this will have on our work, particularly after the finding of probable cause on a particular complaint. For example, in this scenario, the statute would require the written consent of the aggrieved person to allow the Commission to intervene in their existing court case after a finding of probable cause. And if the person does not consent, where does that leave the Commission? I think this change could operate to frustrate the Commission's ability to do its job as provided by the KCRA. And in the event the Commission does file in court on behalf of an administrative complainant, the bill would prevent the Commission from recovering its own fees and costs in maintaining that action. I personally don't see the justification to treat government plaintiffs any different than private ones, and I think doing so may create an uneven playing field for aggrieved persons that opt to file with us or for those that are required to file with us due to the barriers to access to the courts. The bill also seems to take a liking, as Chairman Elliott stated, to the housing procedures, which provides that either party to a charge of discrimination can elect to have the claims decided in circuit court in lieu of an administrative hearing. And I think some middle ground can be found there. Perhaps the bill could be written in a way that provides the same election provision in the employment and public accommodations cases, or perhaps the bill would allow for local commissions to file suit for violations of local ordinances. And finally, case filings are on the rise, appropriations remain stagnant or decrease, and the bill does little to nothing to address the time constraints that apply to our overworked staff. Our intake staff and our investigators do a wonderful job, but many of them have long lists of callbacks to make or large caseloads that can be difficult to manage in the time provided by the statute. In sum, I think the legislation's intent is mostly well-founded, but I request the sponsor and the members of this body to work more closely with the Commission to ensure that the language of this bill or any future bills related to this subject matter are thoughtful, targeted, and what's best for the people of Kentucky. And what I tell folks around the state when I speak to them, I say that the statute protects each and every one of us. Each of us belong to a protected class, whether that be race, religion, gender. So the statute affects all of us, and it may affect some of the members of this body up to threefold in the event that some are business owners or employers. Again, the KCRA has substantial reach, and I think care should be exercised when making these changes. I'm happy to take any questions that the body may have, and I appreciate the time to come and speak to you.
Mr. Sells, I think you may have taken all the time. Mr. Irvin, would you like to make a comment? Some comment?
The only thing I would speak to would be in the investigation portion.
Mm-hmm.
I want the body to take in consideration that most of the people we deal with have disabilities. And I'm not talking about even them filing on disabilities, but they have disabilities themselves. So when we interact with them, it could take more time to investigate a case with them. Physically or mentally, they're not able to respond in the same manner as somebody without a mental disability or a cognitive disability. Most of the cases we investigate and close out are disability cases, actually, in the enforcement branch. So I just want to make that clear as far as timeliness of giving them a chance to respond to the respondent, giving them the respondent a chance to gather documentation or them to gather documentation to support their claim. Sometimes they cannot do that as fast as like I could. It might take them longer due to having a disability. So I just throw it out there regarding how this bill addressed time frames sometimes as far as after receiving the respondent's response. I just want to throw that out there that we do deal with a lot of people with disabilities, and as Coach said, we serve the whole Commonwealth of Kentucky and those with disabilities as well, and that is really the big bulk of what we see as of currently in the last couple of years, actually.
Thank you so much. Seeing no questions, it will. Sorry, Representative Marzian.
Thank you, Madam Chair, and I appreciate Chairman Elliott and trying to update things. But I was wondering if there could be some little tweaks from what this gentleman has said to before it goes to the floor, or when it goes to the floor, maybe a friendly amendment or something that you could add to tweak it just a hair. Y'all could work together on that.
Thank you, Representative Marzian, and we have discussed that, and I am open to amendments.
Okay.
And we'll take those into consideration, and I think there have been some good points made by my colleagues here, and
Thank
I
you.
Appreciate their input this morning.
Appreciate you. So maybe y'all two can work together and figure out something. So thanks so much, Chairman Elliott.
Thank you.
Thank you. Raymond Sexton, if you would like to come up and make comments.
Good morning, Madam Chair.
Thank you. If you could
I'm sorry.
turn on your microphone, introduce yourself, and then proceed, and be as brief as possible. There are several others who've signed up. Thank you.
I'll try to be as brief for you. Thank you. My name is Raymond Sexton. I'm the Executive Director of the Lexington Human Rights Commission in Lexington, Kentucky. What we do is, I say human rights commissions are like poison control. A lot of people don't spend their waking hours thinking about poison control, but when you need poison control or you need a human rights commission, people are quick to call our office. And there's a service that we provide. Most of the commissions have been around. Our commission's been around since June of 1963, so we preceded the laws that we actually do enforce. So, and while there may be some good intent to this bill, it's kind of like an onion. The deeper you get into it, the stinkier it gets, because when you get to page 23, there's a section that says a local commission may be authorized to, and then there's a lot of lines drawn through. It said that we can still investigate complaints. However, when you talk about the way that we do our job, a lot of the powers are taken away. For example, Part 2 says compel the attendance of witnesses and the production of evidence by issuing subpoenas, and that is pretty much stripped away from us through my reading of this bill, my interpretation of the bill. So in essence, we can still investigate complaints, but the ways that we do our job is taken away from us. So that's akin to telling police officers, you can still enforce the law, but you can't arrest people, you can't carry guns, you can't force people to testify. So a lot of our work that we do, especially nowadays when we do our investigations, we have the backing of law. Essentially, we're law enforcement agencies. And when we file complaints and people fail to provide evidence, provide testimony, we can actually force them to compel, and it's a necessary part of the job. It seems like today a lot of employers and housing providers are contesting our ability to do our job. And I think through my reading of this bill, essentially all the teeth that our agency has is gone. We'd be allowed to investigate, but there would be no process for us to collect the evidence and things that we need. We have our agencies such as like the Louisville Jefferson County Commission, other human rights commissions across the state. We have the subpoena power. We have contracts with the federal government through the Equal Employment Opportunity Commission on the employment side, as well as Department of Housing and Urban Development on the housing side. So we have necessary contracts with those agencies to conduct investigations. So essentially, our work sharing agreements with those agencies provide that we have enforcement power, that we have subpoena power, that we have the power necessary to do our jobs. So without that, we could be in jeopardy of losing our federal contracts. And nowadays, with the federal government being streamlined, the federal government is relying on local commissions probably now more than ever. We're getting a lot of referrals from the federal government because they don't have the staff anymore. For example, HUD Atlanta, who we report to, they went from hundreds of staff members to under 10 people. So they don't essentially have people, they have inadequate staff to do these investigations. So they're relying on the commissions a lot more. And was my time up? I see some mumbling. So I have a habit of talking way more than I should. So I'll leave it at that.
Thank you. Next, we have Jesse Brewer.
He doesn't wish to speak.
Oh, he doesn't wish to speak. Reverend Donzella Lee. If you would introduce yourself and proceed, thank you.
My name is Reverend Donzella Lee, and I'm the Executive Director of the Franklin Simpson Human Rights Commission in Franklin, Kentucky. To the Chair, Vice Chair, and members of the committee, thank you for your time today. First, I want to appreciate Chair Elliott for working to modernize many aspects of the Kentucky Civil Rights Act, which is about to celebrate its 60th anniversary as the first Civil Rights Act in the American South. However, I am concerned about some of the proposed changes which would remove key aspects of local human rights commission. Local human rights commissions are where we protect and preserve our civil rights. It is our job that we take very seriously in our own communities. And keeping that responsibility within our commissions maintains local control of our laws and our ordinances. I hope we can keep discussing the updates that make sense for Kentucky Civil Rights Act without watering down the protections that ensue. Everyone is treated fairly. Thank you.
Thank you. I see we have a question by Representative Nemus, or a comment.
Yeah, I've got a question. So I got a question and a comment. When the commission submits subpoenas, what's that process there? And if the defendant or whoever's being subpoenaed doesn't like it, how would they move to quash? Would they move to quash to the entity that's submitting the subpoena? Do they go to court? How does that work?
They discuss it, the Kentucky Human Rights Commission.
Yeah, I think maybe he can answer.
Okay,
Or you, whoever.
he can answer.
Okay.
Good morning. Thanks for the question. I think what would happen, I think a respondent would be free to, of course, ignore the subpoena, in which case we would file an original action in court to enforce the subpoena. I think at that time the respondent would be able to move to quash the subpoena.
Of course, as a lawyer, I would never advise a client to dishonor and just ignore a subpoena. That's a court document.
Sure.
It has the backing of law. I mean, if anybody would, I don't think that any lawyer would advise their client to just ignore it.
I would hope not.
Okay, so then they would have to go to the human rights to say, hey, recall this, or I guess they could file an action in court and try to quash it.
Yeah, honestly, sir, that's not come up
Okay.
in my practice, but
Got it. So it seems to me that I have a significant discomfort in requiring plaintiffs or defendants in this matter to go through a process before court. You know, the Kentucky Supreme Court has recently said that we're not, when we had the medical review panels, that the legislature doesn't have the power to put a pre-court requirement on plaintiffs. It would seem to me that it would also be true, or should be true, with respect to the defendants. We ought not have to go through this big process before they have the rights to go to court. And I recently learned that you guys actually, when you find at the end of the adjudicatory process that you have an enforceable order against the business, and that doesn't feel right to me. There's 11 members of your commission. I think only 2 are lawyers, so it's not a judge that we've elected and who is a lawyer and has been through all the requirements to be experienced and qualified. There's none of that on the commission. Yet you are entering what's really a judicial order. There's no jury. I have a right to a jury, And so I don't agree with any of it. So I fully agree with the second part of it. I would agree, however, with an agreement of the parties to submit to the commission's jurisdiction, much like agree to mediate or agree to arbitrate. But I think to the extent that anybody has to go to any entity that's not a court and get pre-approval, to me that should be out. And this is even worse because it allows a non-elected, non-lawyer, non-jury body to saddle these defendants with judgments against them. That to me is horrifying. And so I strongly support this. I would agree with an amendment perhaps to let that be done by agreement. But if what I've said is not true, please correct the record. But if what I've said is true, then it's high time that we change that, I think. Thank you, Madam Chairwoman.
May I respond to that? I'm not saying.
Yes,
Sure.
thank you.
Thank you. I'm not saying what you're saying is not true, but I think what needs to be made clear is that after the administrative hearing process, we retain administrative hearing officers from the AG's office. We request that one be appointed to preside over our matters, and then they do. A full hearing is held. It results in a recommended order under 13B, which then does move to the commission for a final order. After a final order under 13B, parties can seek judicial review of the same, which is the procedural safeguard, constitutional safeguard that's existed, applying to administrative agencies for decades.
Yeah, it's not a constitutional safeguard. It's a statutory safeguard that we've created. The constitutional safeguard is the Court of Justice. I would also mention, and if this isn't true, I want to know this because the fairness ordinance in my town is important to my town. And so I think that Jefferson Circuit Court, for example, adequately defends the rights of all with respect to the fairness ordinance. So if the Jefferson County Circuit Court, the Jefferson Circuit Court is not adequately defending those rights, I need to know that. So because someone said this will reduce the ability to enforce local fairness ordinances, I don't think that's true because you can go to Jefferson Circuit Court. So if they're not adequately enforcing the fairness ordinance, let us know. But if they are, then that statement was false because that adequately enforcing the fairness ordinance in my town is important to me. Thank you, Madam Chairwoman.
Thank you. Is there a motion to adopt House Bill? We have a motion? Okay. Then call the roll if there are no further questions.
Representative Banta?
Yes.
Representative Bauman?
Yes.
Representative Blanton?
Aye.
Representative Burke? Representative Decker?
Pass.
Representative Dietz?
Yes.
Representative Flannery?
Aye.
Representative Griffey? Yes. Representative Kulkarni?
May I explain my vote briefly, Madam Chair?
Yes, please.
I'm going to pass today. I appreciate the intent of the bill sponsor in updating it, and it sounds like there's a lot of areas of agreement. I want to see some actual language in terms of what Representative Marzian said, what Representative Nemes said, because I think there's a balance here that can easily be reached. I'm saying easily, but it's up to all the parties involved. But I would like to see that language in the final version of the bill on the floor, so I'm going to pass for today.
Representative Lewis?
Yes.
Representative Maddox?
Yes.
Representative Marzian?
May I briefly explain my vote?
Yes.
Thank you, Madam Chair. Thank you, Chairman Elliott. And I'm going to vote yes to move this forward with the understanding that you're going to work with the Human Rights Coalition folks and tweak it a bit to get it where we want it. So I appreciate you. Thank you. Vote yes.
Representative Moser?
Yes.
Representative Nemes?
Yes.
Representative Petrie? Representative Roberts?
Yes.
Representative Stevenson?
May I explain my vote, please? I'm concerned that the federal government Human Rights Commission has been gutted. Now we're gutting this commission. So where do people who have no money and no ability to navigate the system go? I agree that if some of the tweaks were made that we talked about today, we could find a good ground. But right now, we're just throwing the baby out with the bathwater and hoping that it turns out well. So I pass.
Representative Whitaker?
Yes.
Representative Williams?
Yes.
Representative Wilson? Yes. Chair Elliott?
Aye.
Zero no votes. 3 pass.
With 16 yes votes, 0 no votes, and 3 pass votes, House Bill 468 is passed and will be reported with favorable expression that the same should pass. Thank you. Representative Cole. Marzian?
Can you record us both as being present? We got stuck in traffic.
You have been.
Did you miss any votes?
This meeting is adjourned. Thank you.
Thank you.